Great. Thank you very much for your help. Hello and welcome everyone. I hope you can hear us in Kyiv, in Stockholm, and online. Today we are discussing a truly historic judgment rendered by the European Court of Human Rights in Ukraine and the Netherlands versus Russia of 9th of July 2025, and we'll touch upon many issues, time allowing, that actually show and demonstrate how and why this judgment is truly historic and very important decision in the history of international law, as well as impactful for the future proceedings, both interstate and other legal proceedings. So I will turn to my colleague Filippa in Stockholm for some welcome remarks, and then we'll proceed with the introduction of our distinguished panelists and the panel, or rather a round table, as we seem to have in London. Over to you, Filippa. I think you are on mute. I think this was the most common remark during the COVID history of webinars, and still is. Yeah. Now we can hear you. Yes.
Great.
Yes.
Welcome to this hybrid conference where we will discuss why this ECtHR judgment in the case of Ukraine and the Netherlands versus Russia that was brought on 9 July 2025 is a unique in the history of international law. And I would like to start with some thanks to the organizers, the Ukrainian Bar Association, and to the host, the Sokorenko law firm in Kyiv, and a special thanks to Vladislav Badrovsky, who's a senior associate there, and also thanks to Writing Case in Stockholm and sponsor for hosting this event. And I'm honored to moderate this esteemed panel together with Natalia, who's a disputes associate in London. And back to you, Natalia.
And of course, my co-moderator, Filippa, disputes partner at Writing Case team in Stockholm. And we are very fortunate today to have with us in person and remotely in Kyiv and Stockholm an excellent panel of speakers with first-hand knowledge of this historic case. So please join me in welcoming Marharyta Sokorenko, who joins us remotely from Kyiv. Marharyta is an agent of Ukraine before the European Court of Human Rights, an honored lawyer of Ukraine. Sitting right next to me is Team ECtHR of Blackstone Chambers in London. Team is leading counsel for Ukraine in the case that we are going to discuss today. Dr. Olga Kuchmiienko, Ph.D., who joins us from Stockholm, attorney at law and chair of the International Law Committee of the Ukrainian Bar Association. Dr. Ganna Yudkivska, welcome Hanna, who joins us from Kyiv, I believe, former judge of the European Court of Human Rights in respect of Ukraine from 2010 to 2022, partner at Equity Law Firm, chair of the UN Working Group on Arbitrary Detention, and vice president of the European Society of International Law. Welcome, Hanna. And last but not least, we have Dr. Anna Bukvych, Ph.D. and attorney at law and the deputy chair of the International Law Committee of the Ukrainian Bar Association. Welcome to you all. And before passing back to Filippa in Stockholm to get us started, I would like to extend special thanks to our trainee solicitor, Priya Sandhu, here in London, who kindly helped to prepare this panel, or rather this roundtable. Over to you, Filippa.
Thanks. And just a few housekeeping remarks before we start, reminding you that all speakers provide their comments in a private capacity, and all your questions are very welcome via the Q&C function if you're online, and if you're present in any of our locations, please just raise your hand whenever. And without further ado, I'd love to turn to our first speaker. Thank you for joining us, Marharyta. I understand you have worked on this case from the outset, and this case concerns 3 interstate applications filed by Ukraine regarding the events of spring 2014, plus an application filed after 24th February 2022. And many commentators say that the judgment sets a historical record through setting out the facts and articulating how the law applies to those facts, which is crucial given the misinformation around the conflict. And I also understand that there are over 9,000 individual applications related to the Russian Federation's aggressions since 2014 that are likely to be impacted by the court's findings. So please, can you walk us through the facts of the case?
Thank you, Filipa, and distinguished colleagues and participants of this an excellent event. Today I have both a great honor and privilege to participate in this critically important discussion and to be the first panelist in this discussion, and particular alongside with such distinguished speakers in our panel. And I'm very glad and happy to see also Team Oti, who is our counsel in this our case, and also Ganna Yudkivska, who was the judge of the European Court of Human Rights and who also worked from the very beginning with this case of Ukraine, but from the side of the court. And also I want to extend my gratitude for organizers, Ukrainian Bar Association, and the host that you arranged this event and bring together legal professionals and participants to discuss this remarkable judgment from several countries. So thank you very much for this. I do believe that today's discussion, it will be our collective exploration how not only how this judgment is important and what this judgment means for the international law, but also how it was achieved and how it can be used in our further work. Filipa, you mentioned that number of commentators named this judgment as historical, significant, remarkable, as a legal victory. Yes, I was also one of those persons who also named this judgment after the in this line right after delivery. But when we actually celebrate, because it's very important judgment, and when we celebrate this judgment, we must remember that achieving this decision required lawyers to traverse on extraordinary complex path. And this work of the lawyers of during the whole period starting from 2014, it extended beyond the traditional or conventional legal proceedings. Nevertheless, I was indeed one of those members of the team who worked with the interstate cases of Ukraine from the very beginning, from the first submission in March 2014. And at that time, we realized that it was our first interstate case in the history of Ukraine before the European Court of Human Rights. Like, we did not have some similar cases before. So it was like new work for the legal team. But nevertheless, we decided, the government decided that in order to protect the human rights before the court, and given the development of the human rights violations even during the first day of the Russian aggression, that the Ukraine needs to use this instrument of international interstate applications before the European Court of Human Rights, and we submitted the first interstate application in March 2014. Then after that, unfortunately, the Russian aggression only escalated, and and that was the reason why Ukraine continued to supplement its application or to submit some additional complaints to the European Court of Human Rights. So in result, during 10 years, during this period of 10 years, Ukraine submitted to the court 10 interstate applications, then subsequently were merged into 4 main proceedings. And on this slide, you can see like we have 4 key proceedings. It's Ukraine versus Russia regarding Crimea, where we already received also the judgment on the merits last year. Our recent judgment, Ukraine and the Netherlands versus Russia, which includes human rights violations from spring 2014 and during the full-scale invasion. And another 2 cases, Ukraine versus Russia, number 8. It relates to the to the attack of by Russian forces of Ukrainian naval vessels in Azov Sea in November 2018, and Ukraine versus Russia 9 case relating to the practice of the extrajudicial killings and assassinations of individuals who Russian authorities consider to be dangerous for the Moscow regime. Having said this, like we have 4 interstate cases before the court, but all those cases, they are interconnected because from the very beginning, we realized that the Russian aggression it was developing, and during which a number of human rights were violated, and and at the beginning, Ukrainian government did not consider to file some separate applications regarding Crimea, regarding Eastern region, etc. It was at the beginning one interstate application that subsequently was supplemented, and at some point the court decided to separate those applications given the geographical criteria for proper administration of justice, and this was the way how we received the case regarding the big proceeding regarding Crimea and the case regarding Ukraine and the Netherlands versus Russia. In the beginning, it was named Ukraine versus Russia regarding Eastern Ukraine. But it was important for us to demonstrate the court that those cases are interrelated, and all the complaints and events and facts we described in those cases, they are related to the one Russian ongoing aggression. And in this slide, I was trying to demonstrate in simplified manner how they are correlated. Those like everything started from the Ukraine versus Russia regarding Crimea, and then developed in the case related to the Eastern Ukraine and full-scale invasion. Also. Our legal team had not just a simple the task to list some types of human rights violations, but we realized that we had not only to find evidence for human rights violations during the real time because of the ongoing war, but also we realized that we had also a challenge as one of the challenge for documenting the crimes because they occurred occurred on the territories that were not accessible of Ukrainian authorities. So we need to develop methodologies with using and obtaining the evidence in order to substantiate all our complaints. And in fact, during all 10 years, we used also not only materials from the domestic authorities, from the investigation, but we also worked directly with the victims, with the witnesses of human rights violations, including we managed to receive remote testimonies from people who were on the territories that were not under Ukraine's control, used information from satellite imagery, etc. But also we realized that these human rights violations, they will span and they developed not only in time, but also in geography. And it was important to provide this Ukraine's compliance in such manner that to demonstrate the court the pattern of Russian occupation and human rights violations, and how it developed from the very beginning of the occupation. It was late 2014. So in fact, Ukraine realized that when we filed the interstate application to the court, we posed before it quite challenging and tricky task, and it was not easy also to consider the court all those complaints. Then I also must say that for me, like we today speak only about Ukraine and the Netherlands case, but for me and our team, we do not distinguish. In fact, like we do not read this judgment as separate one because for us, this judgment is part of the broader, bigger picture of the Russian aggression and the human rights violation. When we turn to this judgment, it includes 4 applications. The first one that was started from the first interstate application lodged in 2014. Also, the court joined the interstate application regarding the kidnapping of Ukrainian orphan children by Russian forces and their transfer to the Russian Federation. Then in 2020, the court joined to our case the interstate application of the Netherlands regarding MH17 case, and the last one was Ukraine versus Russia, 10 related to the human rights violation in the course of the full-scale invasion. And in this case, it's also important that in 2023, in January 2023, the court delivered its admissibility decision. It's also an important part of this of our interstate judgment, because a number of key findings the court already indicated in this admissibility decision. And after the court delivered this admissibility decision in Ukraine and the Netherlands versus Russia case in 2023, court then also decided to join the last application regarding the full-scale invasion to these proceedings. It was our additional challenge, because we understand that the scope of the application regarding the full-scale invasion was much broader and covered somehow also new complaints. But still, on the other hand, it was very good tactics on the part of the court, because we managed to demonstrate how the human rights violations occurred and continued in 2000, since 2014, how they developed after the full-scale invasion. Why this judgment is so important and remarkable, significant. It's important, first of all, because it's the first judicial decision of international court where you can find the description of how the nature of the Russian aggression was changed from 2014 until and after the full-scale invasion. So we have in this judgment a recorded chronology of the development of the Russian aggression and the chronology of development of the human rights violations on the occupied territories. Also, it is important part. It's not directly indicated in this judgment, but it's important that when the court found all those human rights violations on the part of the Russian Federation and recorded and described the factual circumstances and development. In fact, the court also deprived the Russian Federation to disseminate their disinformation, propaganda, and narratives regarding Ukraine and its Russian aggression against our state that we saw during the whole process. Also, it is important that this judgment also includes broader context of the human rights violations. From the very beginning, Ukrainian government realized that in order to demonstrate and to prove before the court that the scope and the level of those patterns of the human rights violations on the occupied territory, we need to demonstrate the court the context of these human rights violations, and first of all, what influenced on that context, on the severity of those crimes committed against our people on the territories. And the court found not just that there were some human rights violations, but the court indicated that they are related to objectives, to key goals of the Russian Federation regarding Ukraine. And you can see in these paragraphs that the court indicated that the Russian objectives were and still is destruction of Ukraine as an independent state. And the court also even decided to elaborate more on this and indicated that it also that we also have the cases when such goals and such narratives extend beyond Ukraine. This is the important part because the court took into account the general context of these of all the events regarding Ukraine and their possible influence, not only for the convention system but also for the region, for the security issues and the rule of law issues in the European continent. And this also was indicated by the court, as you see in this paragraph. The court first of all highlighted that this case of Ukrainian case was unprecedented in the history. Not only the court but the Council of Europe was unprecedented. The case and the conflict was unprecedented after the Second World War. Also, the Russian Federation, being till 2022 a part of the Council of Europe and contracting state to the Convention for Protection of Human Rights, used being the member of the Council of Europe, their actions against Ukraine represented a threat not only to the rule of law and human rights respect, but to the existing peaceful coexistence in the region. And also the court also mentioned about several occasions when such actions and dangerous rhetoric also extended to some other member states, in particular Poland, Moldova, and Baltic countries. This is also important because these countries and countries in that region have now individual cases related to the security concerns. So this findings of the court is also important for their proceeding. Also,
thank you, Marharyta. I wanted to just because we are tight on time today, I wanted to ask you to conclude perhaps with like the major wins for Ukraine on this case, as we have thousands of individual applications pending before the European Court of Human Rights. What impact of this judgment? Obviously, there is still a decision pending on just satisfaction and deferred issues, but what are the major wins for your team, for the government of Ukraine, as the applicant in this case?
For our team, it was the key. First of all, it was the key victory for us. It was that the court almost fully accepted all our complaints at the court, because it was important for us. This proceeding was not just about some legal process. We realized that this proceeding is about some future means for the government, for the state, in hard work, not only on in international judicial proceedings, but for foreign policy and diplomacy, have to work with our partners in order in order to make the Russian Federation to end all those human rights violations. It was not an easy task from the very beginning, but now we can see that these findings, they will be important. They already are important for the further establishment of the compensation mechanism. Last week we had final consultations regarding the establishment of the commission on complaints within the compensation mechanism, and we already received the text of the agreement on its establishment has already been published. Today is also in the process of negotiations and work regarding the returning of deported Ukrainian children. This is one of the key issues discussed today by Ukrainian delegation in the United States at the UN session. But it also was good, this judgment facilitated the consideration of individual cases. You mentioned near 10,000 before the European Court of Human Rights, but it's also important for other proceedings, not only in European Court of Human Rights, but also international criminal courts and future tribunal for crime of aggression.
Thank you. Yeah, we'll come to that a bit later in this presentation. And I suppose, I mean, the historic nature of the judgment is also, and the very detailed fact-finding exercises reflected in 497 pages by the European Court of Human Rights, that constitutes a very comprehensive record of the events, rather tragic events that happened in Ukraine. And now turning from the facts and the decision itself to some legal issues in this historic judgment, I would like to pass on to a team who led the Ukraine Consul team on this case. And I particularly wanted to ask you about one important, I think, jurisdictional legal issue that was clarified, or I would say elaborated on by the European Court of Human Rights, and that further extended Article 1 jurisdictional jurisdictional issue from Bukvych case, where the bombing was considered to be not an exercise of effective control outside the territory, or rather geographic territory controlled by one country over the other, or Cyprus versus Turkey, where the non-governmental groups were also outside, if they were considered not agents of the state, exercising the state's powers. And also, European Court of Human Rights, interesting findings, kind of avoiding or distinguishing rather Georgia versus Russia too, in the context of the situation of chaos and ongoing hostilities, where it is difficult to determine the nature of the actions and the exercise of the effective control over territory. So over to you on Article 1 jurisdiction and any other legal issues that you found rather novel or key in this judgment.
Thank you very much, Natalia. I'd like, before getting into the law, if I may, to pay tribute to Marharyta and her team as well, and to perhaps paint a bit of a picture for everyone online or here of quite how extraordinary it was for them to be working on this case in the context they were. I first met Marharyta on Zoom, I think at the beginning of March 2022, and I would have frequent meetings with Marharyta and her colleagues where I would be sitting in the comfort of my room in the temple looking at a very peaceful garden, and across my Zoom screen I would see Marharyta and her colleagues in basements spread across the country, curtains closed. On almost every meeting, at least one member of the Ukraine team would have to leave to go to a more secure location because a siren would go off. And despite that, throughout the 2.5 years that we then fought the case, they showed extraordinary resilience and professionalism in the way they conducted this case. So a personal tribute to start with, if I may. Right at the outset, we identified that the question of jurisdiction was a critical one and a major obstacle because of the Georgia 2 judgment you've described. As many on this call will know, in January 2021, the Grand Chamber of the European Court of Human Rights handed down judgment in Georgia 2 against Russia, relating to Russia's incursion into Georgia in 2008, and refused to take jurisdiction over events occurring in the course of active hostilities between armed forces, what it characterized as a context of chaos. And the immediate concern was that that would provide a fundamental barrier to Ukraine asserting jurisdiction on the part of Russia over the violations it wished to complain of. As you'll all know, the convention imposes obligations on all signatory states to protect the fundamental rights of those persons within their jurisdiction. That notion is primarily territorial, but has been held to extend in the past to areas occupied by an allegedly offending state, or to individuals taken into the custody of an allegedly offending state. What it had never extended to was cases where violations were perpetrated, for example, by missile or bombing or shelling, where there were no boots on the ground of the aggressor state. And so, to give just one example, it begged the immediate question: could someone in an apartment block in Kyiv, hit by a cruise missile on the 25th of February 2022, claim against Russia? Or would Russia be able to successfully contend that that person was never within its jurisdiction? Now, in confronting that obstacle, we adopted both a legal and a political strategy. The legal strategy was, in essence, to remind the court that the convention and the entire Council of Europe system was a peace project created to prevent war ever occurring in Europe again. And so the convention had to be interpreted in light of that fundamental purpose, in accordance with conventional principles as to treaty interpretation. And to do otherwise than to take jurisdiction would leave a vacuum at the heart of Europe and would essentially involve the court abdicating its fundamental role under the convention system. The political strategy which went alongside that was to engage with other sovereign states, because we recognized right from the outset that the more states that we could persuade to intervene in these proceedings, the more comfort the court would take in treating this case as truly exceptional and not seeing itself as bound by Georgia II. And the result of that, through engagement by Marharyta and her team and through those operating in London, was that we had 26 states intervening in the case by the time we came to the main hearing in Strasbourg in June of 2024, all of them broadly supportive of Ukraine's position, all of them recognizing the critical importance of this case for the entire convention system. We were also helped in this case by the extraordinary facts at every turn, not just the flagrant and extraordinarily disturbing human rights violations that were occurring at Russia's hands every hour of the conflict, but also by the brazen statements made by those in power in Moscow. We drew to the attention of the court a publication which had drawn all of these statements together and had the apt and chilling title, Russia's Eliminationist Rhetoric in Relation to Ukraine. There were statements from Putin, from Medvedev, from the head of the Duma, all calling for the complete destruction of Ukrainian sovereignty and the subjugation of a sovereign state within the Council of Europe. And that provided the most powerful basis for distinguishing Georgia II. And in its judgment, the court emphasized these themes repeatedly. But in the end, the critical paragraph on this question of jurisdiction is probably paragraph 361, where the court directly addresses this question of context of chaos and whether its earlier analysis in Georgia II stood in the way of Ukraine's case. And it held in terms that what was happening in the case of Russia against Ukraine and Ukraine against Russia in the court was anything but chaotic. It was a brutal strategy conceived in Moscow and executed according to Russian instruction across Ukraine. There was nothing chaotic about it. There was no difficulty in adjudicating upon it. The facts were clear and spoke for themselves. And so on that basis, critically, the court held that not only were the people caught up in the atrocities of Bucha and elsewhere, obviously within Russia's jurisdiction, but every single person, legal and natural, so real people, corporate entities, every single person affected by the military attacks had to be treated as within Russia's jurisdiction so as to open the gateway to declarations of violation. And importantly, to compensation, because the result of that very broad finding on jurisdiction is that every single person affected, again, legal and natural, by Russia's military attacks is entitled to compensation from Russia under the convention system. And the court, as it often does, adjourned that question of the quantification of compensation to be considered at a later stage. But we had already put in preliminary evidence showing the scale of damage to be way beyond $300 billion. And I'm using that figure because, as you'll all know, that is the broad estimate of Russian state assets which are currently frozen in Western democracies and which are potentially susceptible now not simply to freezing, but seizing and transfer to Ukraine. So it's been described, this judgment, by the former president of the European Court of Human Rights, Robert Spano, as the most significant judgment in the 65-year history of the court. And that is not an overstatement. It's a profoundly important historical document, as Marharyta has said, because in a world which sometimes finds truth elusive, it provides a judicial record of the sheer scale of violations and the brutality that Ukraine has undergone over the last 2.5 years. And that in and of itself is worth something in historical terms. But in more practical terms, it opens a real pathway now to the seizure of Russian state assets, which perhaps did not exist before, because it shows that that seizure and that transfer, far from being in conflict with international law principles, would be in compliance with international law and would be discharging at least part of Russia's international law obligations as they flow from this judgment. So those are I think the key legal issues. It certainly opens a clear pathway jurisdictionally to all the other 9,000 claimants. It is of great moment and extraordinarily important. One perhaps other unique aspect of this case to draw to people's attention, as will become obvious to anyone who's read the judgment, this is probably the conflict which has, of all conflicts, been susceptible to more day by day, hour by hour observation, thanks to the advances of technology. We had people on this case with the barrister team in London, with the government team in Ukraine, and with Quinn Emanuel, working 24 hours a day in offices as far-flung as Kyiv, as London, as New York, as Sydney, documenting a master chronology, hour by hour, capturing every single event that was being recorded anywhere on any form of media, so as to present the court with the true scale of violations occurring. And it was that exercise, I think, which made the court's task both easier and inevitable in its destination. Confronted by that sheer wealth of material, the leading human rights court in the world simply could not turn its eyes away from its obligations or from what was occurring on the ground. And so it was a huge collective effort which led to this outcome. And it's now, I hope, not just an important historical milestone, but an important springboard for Ukraine to obtain some form of real accountability in monetary terms against Russia.
Thank you, Tim. And just in your personal opinion, would the outcome have been different should Russia appear?
I don't think it would have been different should Russia have appeared. I think the hearing would have been longer, but the weight of evidence was so overwhelming that the outcome would have been the same. As a matter of legal analysis, as you'll see from the judgment, the fact that Russia only participated in the very early stages of the proceedings and simply refused to offer any cooperation to the court was one of the matters we relied upon in saying to the court, if you have any doubt as to whether the standard of proof has been discharged here and met, you can draw an adverse inference against Russia. And the court was content to do that. But as I said earlier, the objective evidence from respected reporting, both in terms of the media and international organizations, and the particularly damning evidence from the mouth of those in power in Moscow themselves, made the conclusion irresistible in any event. So it would have been delayed, but it would have led to the same outcome.
Thank you, Tim. I'm sure we'll have some questions on the jurisdiction and other legal issues, but now over to Stockholm.
Thank you, Tim. Turning to Olga now here in Stockholm. As we heard from Tim, the judgment constitutes the authority's statement on how the ECtHR could apply extraterritoriality in armed conflicts in the future. And as such, this decision is truly historical and immensely important because it opens the door to the processing of individual applications that Ukrainians have filed against Russia, as Tim just mentioned. Can you please elaborate a bit on how the judgment shaped international legal knowledge of effective control?
Thank you, Eva. Yes, My name is Olga, and today we will talk about the effective control in the European Court of Human Rights decision in the case of Ukraine and Netherlands versus Russia, and why does it matter? We will talk about what is effective control, how was this concept applied earlier in the so-called Crimean cases, other criteria applicable to the territory of Eastern Ukraine, which criteria are applicable, and most importantly, why does it matter? You all have seen the map. It's where Marharyta's map was better, but you can see that the red parts have been or are under effective control of Russia, including according to the European Court of Human Rights findings. And before we start, I will cite the court. The start of the Russian invasion of Ukraine on 24th of February 2022 represented the continuation and escalation of the strategy pursued by Russia since 2014. And to make this long story short, I would just say, what is effective control? Effective control is an occupation, and the European Court of Human Rights basically didn't distinguish between the de jure and de facto control, and considered that both controls were represented in the effective control concept. And this long story constitutes about 10 arbitral tribunals decisions in Ukrainian cases and a few decisions of the European Court of Human Rights, which refers to effective control. So how was the concept of effective control applied in so-called Crimean cases? Again, to be very short, tribunals mostly refer to the ability to legislate, substitution of the state authorities, and obtaining the permission of the other state to the wrongdoer's presence in the territory, which means that Ukraine didn't permit and basically objected against Russian presence in its own territory. But other criteria for effective control over the territory applicable to Eastern Ukraine. Yes, and Ukraine held this position for more than 10 years, and the European Court of Human Rights supported this position in its preliminary decision, so which Marharyta has referred to, and in its final decision in July 2025. And some details of this, yes, stem from the factors that are happening in Ukraine or have happened earlier. So basically, the main thing that the court has referred to is that this illegal scenario of occupation of Ukraine that was applied in Eastern Ukraine by Russia started from intense fighting and then evolved in effective control, occupation, and annexation. And this was basically the position of the court, the position of Ukraine that was supported by the court. The second part of the factual backgrounds is that how this effective control happened. So basically, argument of Ukraine was that Russia had proximity power to control their territory and control over the territory even before the physical presence in the territory, boots on the ground, via its proxies. And that made it possible for Russia to commit violations under Article 1 of the Convention. But now I will invite us to talk to look a bit deeper than just Article 1. Which criteria for effective control over the territory are applicable to Eastern Ukraine, and which criteria court has referred in its decision? So basically, that was certain events that took place in the territory under separatist control from May 2014, accordingly fall within Russia's jurisdiction in the meaning of Article 1. Then a second criteria was the decisive degree of influence and control Russia enjoyed over the areas. And thirdly, it is Russia's military, political, and economic support of the proxies, basically of the separatists, since 2014. That criteria a court has stated in its decision in 2023. In the decision of Grand Chamber in 2025, the court referred to this criteria, but then analyzed much more factual circumstances, and team just referred to it as a manual that the team has gathered. So in the next slide, you either can just take the picture if you want to have the citation, or just read the headings. So basically, the criteria that the court has applied in 2025 decision It was ability to legislate and absence of the evidence about decrease in this ability. So basically, courts refer to it as a continual jurisdiction in the so-called areas. Then substantial military presence, and this conclusion is not undermined by the fact that Ukraine has taken over control over some territories later, and other features of effective control that were cited in the decision. And it is important that court has said that, okay, but Russia has managed to operate the separatist operation in general. Russian troops were deployed in the border. Then there were training in camps. There were senior members of Russian military that were involved in all this operation. Then the political hierarchy of Russian Federation was applicable to these military separatist entities, and some personalities were included there. And which is even more important, Russia has supplied weapons and other military equipment on a significant scale. So if you read this list of things that Russia has done, that helped to say that there was an effective control. And finally, all acts of the separatists are attributable to Russia. So why are we talking about that, and why does it matter? I will talk about key takeaways, why does it matter, and how can we apply these findings to other cases. So basically, key takeaways. Russia has been holding effective control over eastern Ukraine since 2014. Russia has been saying for 10 years that they are not there, that it's an internal conflict. No, it's not that. The European Court of Human Rights said that it's not that. Russia held effective control over other territories, or other than that red territories that I just showed, and they might have been taken back, like Kherson, for example, but it doesn't mean that there was no effective control and no violation at the time when there was an effective control. Thirdly, European Court of Human Rights mentioned that Russia could have held effective control over other territories of Ukraine. And in Marharyta's map, you could have seen that blue areas near Kyiv. So can we talk about effective control over some small territories for the time being? I don't know. What does it mean for us? First of all, if Russia holds effective control, Russia is responsible for violations of rights over that territory. For example, other cases and other tribunals might think, okay, investors' rights, where are they violated there? Can this tribunal be inspired by this decision? Maybe. Then individual applications against Russia in the European Court of Human Rights can be reviewed now, and I will let Ganna to talk about that later. Then claims to arbitral tribunals may use this decision as an inspiration manual, find ideas how to substitute that Russia was there, and maybe use this decision as something that reflects or impacts customer international law. And finally, international courts considering cases against Russia and its official also may use this decision for the same purposes. Why? And now, how can we apply these findings? So basically, these findings are important. We concluded that Russia held effective control. How can we use them? So the decision had a huge impact on the idea of effective control. The decision interpreted this term in connection to the term of territory. So it means that future claimants and future tribunals might consider findings and arguments set in this decision when interpreting the term territory under Vienna Convention of the Law of the Treaty, Articles 31-32. And then how do they do that? They will think, okay, what is the ordinary meaning of the territory when I interpret the treaty? And then they will think, okay, where can I find it? They will think probably about public international law or to the common understanding of this term. Public international law in Article 29 and Vienna Convention of the Law of the Treaty refers to the moving treaty frontier rules, that the treaty is applicable to the entire territory, including the ones that is acquired later, but it doesn't say that it shall be legally acquired. So legally acquired effective control, can we talk about it? Probably yes. Then common understanding of this term, then arbitral Crimean cases, then European Court of Human Rights decision. Does it mean that ordinary meaning of the term territory now may include effectively controlled territory of the state? Probably, yes. And speaking even more practically, can the investors that lost their property in other affected regions of Ukraine refer to arbitration against Russia using European Courts of Human Rights approach, argument, and findings? I'm not saying referring to the decision. I am saying be inspired by this decision. Yes, and there are many companies that lost their properties. Cargill is Danone, it's Metinvest, Heavy Machinery, it's Agriculture, Equivalent Farming, and you can find many more. Then, can Ukrainian investors claim Russia using this case based on VATs with Russia? Can we find rules and legal framework to waive Russian immunity and arrest Russian property abroad, taking into account the character of the violations? Can other states that suffered Russia-alleged occupation enjoy the lessons learned? And finally, can these findings be applicable to other conflicts? I will leave it to our speakers, Ganna and Anna, that will talk about impact on tribunals and the court. But I will just conclude that this decision may be served as an inspiration for the tribunal. Many of claimants can reflect customer international law or may impact the customer international law. And yeah, it might be not binding for the tribunal, but so what's the same with ICJ decisions, but we still refer to Corfu Channel decision and other decisions when we apply the jurisprudence. So I think that this decision helped to develop public international law and the approach to the territory. Thank you. I think
you're right on time, Olga. Super. So many thoughtful questions. Thank you for that. And now we're turning to Ganna, who kindly joins us from Kiev. Just to start off, in this judgment, it's the first time in history the European Court of Human Rights has ruled in a case that involved two Council of Europe member states against another state that is not a member of the Council of Europe and not a party to the ECtHR. It's also the first interstate case where the respondent state is not represented by a judge elected in respect of the party to the ECtHR or by its government agents. And we've seen that the court allows submissions from the 26 member states, which I understand is also unprecedented. Ganna, can you please comment, based on your experience sitting as a judge in the Court of Human Rights, the impact of this judgment on future interstate cases and international jurisprudence overall?
Thank you very much. Actually, it's my great pleasure to be present here and to participate with so distinguished co-panelists, and also my greetings to the Whiten case, with whom I had a wonderful cooperation last year when I judged the final of JESUP. And as Marharyta said, well, I lived, so to say, with this case in the court since 2014. And allow me to start with what I know a little bit deeper from inside, that's the admissibility decision in this case of 2023. So there the court already found in this decision that the areas of Eastern Europe controlled by separatists were at least from 11 May 2014 and up to at least 22nd January 2022. Why this date? Because it's the date of hearing in the admissibility decision. So those parts of eastern Ukraine were under jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention. So basically, this admissibility decision of 2023 represents the first international judicial determination that Russia exercised the effective control over the territories so-called Donetsk and Lugansk People's Republic. And when you read this admissibility decision, I think it's clear for the readers that the main debates in this decision, basically they recognized admissible almost all complaints submitted by the Ukrainian government, but it's clear that the main debates were around the most contentious legal issue of jurisdiction over bombing and shelling incidents. And that was, as Tim just explained, it was precisely the type of conduct of hostilities that previously, just 1 year ago, before that, the court excluded from its jurisdiction in this heavily criticized Georgia versus Russia II judgment. And for me personally, this was a crucial moment, and Tim just raised brilliant arguments how they build strategy against this very sad conclusion, and I'm happy to hear that. And you might know that those judges in the Georgia versus Russia II, including myself, already raised these arguments in our dissenting opinion. So that time in 2021, we were 7 against 10 against this decision to exclude from jurisdiction bombing and shelling incident. And it's very important to notice, and here I think what I will try to explain a little bit, it's what can be called a subjective history of international law. Georgia versus Russia II, we discussed before the full-scale invasion to Ukraine. And that time, some of the colleagues, again, I cannot state that it was the case, but I assume that some of the colleagues might believe, well, it was a kind of maybe isolated event. Maybe we should not go so deeply and to recognize jurisdiction over these terrible war acts because we will get into big troubles with such decisions. And then we had hearing on MH17 and Ukraine, actually bombing and shelling of Ukrainian territory on 26 January 2022, less than a month before the invasion. And I remember during the hearing, I think it was Ivan, our governmental agent at that time, who said that, well, look, Russian tanks are just at Ukrainian border. So, you know, well, tomorrow we might face really very serious consequences. And that time, again, 1 month prior to the full-scale invasion, it might sound unrealistic. But then we had the second hearing in the same admissibility decision discussion, already in November 2022, when Russia already heavily bombed all territory of Ukraine. And this timeline again shows how views of judges who decided on this issue transform a little bit with the time, and not with the time, with the circumstances surrounding those cases. So in the admissibility decision on MH17 Dowling, we applied already immediately distinct jurisdiction reasoning to distinguish from Georgia versus Russia II, because there we said, well, yes, it was also in the context of chaos, but we have here very detailed investigation by the Dutch authorities. Dutch authorities concluded that the aircraft was shot down by a Bukvych missile. So here we have quite, solid basis to find, to distinguish MH17 from this context of chaos doctrine. So there the jurisdiction was established. But when it came to the complaint of administrative practice of bombing and shelling under Article 2 of the Convention, so here again, on the one hand, it was already November 2022, yeah, so we had this bombing by Russian Federation of the whole territory of Ukraine. On the other hand, Georgia versus Russia II was only 1 year before. And those judges who were in majority in Georgia versus Russia 2 were still present in Ukraine and the Netherlands versus Russia. And then we had reached a solution. It was paragraph 700 of the decision that, well, we leave this issue to the stage of merits. We said that the question, this question where was state agent authority and control in respect of acts of shelling in the present case, such as to give rise of the respondent state's jurisdiction, requires very careful examination to see whether they can be identified as the context of house under Georgia versus Russia 2. So we joined it to merits. On the other, in other words, we let next generation of judges to deal with this issue. And in this crucial July 2025 merits judgment, the court finally resolved the bombing and shelling question jurisdiction through its harmonious interpretation methodology, rejecting clearly this Georgia versus Russia 2 context of house, and the court established, and I think it's a brilliant formulation, that there is no circumstance in which international humanitarian law will apply to the complete exclusion of the convention's human rights guarantees, and that the convention should, as far as possible, be interpreted in harmony with other rules of international law. And that's exactly what we claimed in our dissenting opinion in Georgia versus Russia. So chapeau to the judges who, in July 2025, adopted this, by the way, unanimously, this judgment on merit. So the court took here an expensive approach to Article 1 jurisdiction, covering all of the incident concerning the use of kinetic force, conduct of hostilities in 2014 and 2022 that were at issue in this case, so completely overturning this previous exclusion of military operations from human rights scrutiny. Nevertheless, some language in those paragraphs of the judgment I've seen was also criticized by some colleagues because, colleagues in the academia, because some scholars argued, well, this court's harmonious interpretation approach still leaves some unresolved issue. What are the boundaries so far as possible, and which rules of international law are relevant to the interpretive exercise? So, for example, if international humanitarian law rules were so to say, respected by the attacking power, would still human rights under the convention would be violated or not? And of course, the court in this particular case, to our, again, greatest satisfaction, overruled Georgia versus Russia 2, but still the court, we could see from the very particular language, the court still left a little bit of room for maneuver. And in my view, it was in the first place to satisfy those governments among those 26 who tried also in quite subtle way to preserve the existing Georgia versus Russia 2 formula. And I'm speaking now about France and UK mostly. If I remember correctly, those were those governments who insisted somehow that, well, maybe in this particular case not, but Georgia versus Russia 2 still should be preserved. And in this respect, I want to share with you again some observations how the attitude changes. Speaking about the Netherlands, the applicant government in this case, I remember Jalud versus Netherlands case, where a young Iraqi was killed when the car in which he was a passenger was fired up while he passed through checkpoint, which was under the command and supervision of Dutch military. And actually it was a Dutch soldier and potentially Iraqi soldier who were firing at the car. And there the Netherlands strongly objected jurisdiction. So they insisted that no extraterritorial jurisdiction should exist. Well, in this case, you see the Netherlands completely changed their mind in respect of extraterritorial jurisdiction because, well, when you consider your country participates in some peacekeeping operation and somewhere in Iraq someone killed, why you should be responsible? So that's the way of logic. But then you have a plane full with your citizens, which was fired down by some extraterritorial force. Of course, you wouldn't see that extraterritorial jurisdiction should exist and should apply. I in no way want to say that France and UK might change their approach if bombing and shelling would come closer to their border. I don't want to imply this, and of course that's not something we can even consider. But this is fascinating how circumstances change different states' attitude toward legal issues. And again, I'm sorry I devoted, I think, half of my time to this history of international law question, but I believe it's per se is fascinating. And speaking about this impact, and again, particularly this issue of military operations and chaos, we will see how the court will apply it in other situations, in other war-related situations. Again, I hope no more war-related situations will come before this court. We thought we would see how the court would apply it in the cases submitted to the court, submitted by Armenia against Azerbaijan and by Azerbaijan against Armenia. But you might know that, well, recently both states signed peace agreement. And one of the points in this agreement is that both states withdraw their cases, their applications, both from the European Court of Human Rights and International Court of Justice. This was, of course, predictable as soon as anyone speaks about peace agreement, but, and we, of course, we immediately might think about potential peace agreement, which, again, people today are discussing. One day we might enter into peace agreement with Russia, but I believe it will be detrimental for the international law as such if any similar provision would be in this agreement, and it's clear that Russia would really insist on it. And we consider not only these cases, not only compensation cases, which will be, again, it will be a huge wave now of the compensation cases, as was already underlined by the colleague, but it will be detrimental for this tribunal for crimes of aggression, which I hope, and we all hope very much, will start working very soon. So
thank you very much, Hanna, for these comments. We'll leave some other points for the Q&A, which will be unfortunately cut short now. But talking about other impacts of this judgment on the international jurisprudence and arbitrations, including investor-state arbitrations, I just wanted to give a chance to Anna Bukvych, who joins us here online as well, to provide a few brief remarks on potential impact of the findings and the judgment on investor-state cases. Thank you, Anna.
Yeah, thank you very much, Natalia. Thank you very much, all guests and participants. Indeed, it's very useful and very interesting session we have now, and very important for future and for some summary of what have been done for this landmark decision. So I would start perhaps with not so direct and evident impact of this decision, especially on the arbitrary decision. First of all, as we know that it's not like a pure judicial point when we can investigate and go to the deep details, but as we know that the arbitrations can also use the practice of the European Court of Human Rights as the supporting argument. And we have a lot of cases in this respect, especially protection of the investors and protection of the rights of investors when they use this supporting argument to support their decision on the application of such or some rules and principle. As well, this argument can be used in the application claims filed by the parties as well. And I would like to make emphasis on one of the decisions we have so far. It is the case filed when Ukraine received a decision in 1918. It was, and there are very interesting conclusions in their preliminary award, which we have, that can also be compared with those summaries and those conclusions we have regarding the effective control and de facto control over some of the territories. For example, in the preliminary award and after the preliminary hearing, the tribunal found that the BIT did not connect the notion of territory with the issue of sovereignty as argued by Russia. Because if we read all the arguments Russia used, we can notice that they always made impact on the sovereignty and like the formal international law, let's say, that we are not recognize some of the territory occupied by Russia, and it was one of the main arguments that they used in this case. Indeed, I forgot to mention that it is the case they take Kuchmiienko against Russia. Given that there was no dispute that since 2014, Crimean Peninsula remained under Russian effective control, the tribunal found that the claimant's investment was located in the Russian territory. So no way that Russia argued that it is not like they should formally refer to the sovereignty of the territory. The tribunal refused all the arguments suggested by Russia. And that's the reason why the tribunal applied of BIT, and that they mentioned that all the provision of the BIT shall be applied and interpreted in good faith in accordance with the order and meaning to be given to the terms of the treaty in their context and in the line of its object and purpose. And the tribunal also found that the ordinary meaning of the term territory was the entire area within a state's possession of control. So that means that at the end, they mentioned that the tribunal noted that the Russian Federation has actively affirmed their control over this territory. And I think this very landmarking decision, and indeed we do not have a lot of them, since I would like perhaps the parties are very cautious about such kind of decision, and they are very cautious in their arguments they are providing. And this decision, which we have already after dated back like 2018, is also very important in the context of this decision on effective control we have now. So I'm pretty sure that the parties going forward can use this argument in addition to what would be used for such cases, and it will be the good proof for our position regarding the effective control and indeed application of BIT. And also I would like to mention that if there are some few cases regarding Ukraine against Russia on this respect, at the same time, we do not have a lot of cases or in disputes or decisions of other investors regarding their investments on that territory. And I'm pretty sure that given the interpretation we received on the decision we already have from commercial arbitration, and given the decision we have on human rights, as I mentioned, it can be the supplement on the and can be used by the parties in their application as well. And indeed, it is very interesting then, because now we have all the decision Ukraine received now. It's relates to the investment located in Crimea. And then we do not have like any decisions regarding the Donetsk and Lugansk region. And that, I think that this will be good point to be considered and to move forward with this with these decisions and as well. The third one, I would like to emphasize that that there are for sure some limitation when applying of BAT mechanism and applying any protection of investments under this mechanism. And this is first of all the connection between Russia actions and the investor losses. And some mechanisms may have expectation or difficulties were recognizing judicial against Russia as occupied state. And the third, political and practical aspects. I think that this limitation, which we all may have while having and filed our application to the arbitral court, may be avoided and simplified, because we have this clear and very good argument to prove and to justify the effective control during the preliminary hearings. Indeed, I also would like to consider that perhaps this decision will have some impact on the enforcement of the arbitral awards. I'm aware that there are some problems, and it is completely impossible now to enforce any decision in Russia, but perhaps it can, like in future, also facilitate the enforcement of the decision we already have. And looking forward to the maybe any other positive effect which the effective control principle make an effect. I think that it will be good for any other international compensation funds in favor of Ukraine. And for example, we know that we are now signed a mineral deal for Ukraine between United States and Ukraine. So I'm pretty sure that it will have impact on any other disputes may arise as well. And in general, you know that sometimes there are not connection between any human rights and, for example, the protection of investments. But if you're deep in the terror, we can see that like the such imbalance we have between the rights of the state and rights of the investors is almost the same nature as the human rights, and it shall be also protected at the same level, at the same principle as the protection of the human rights. So I think it is the very direct correlation between them, between all these principles, and it shall be applied and I'm pretty sure to be used as the argument to justify the effective control over the territory which is now occupied.
Thanks so much, Anna. Before opening the floor to a shorter Q&A session, rather shorter than expected, I would like to let every panelist to conclude with perhaps a 1 minute, very brief remark or an observation on one significant or notable feature of the judgment in the panelists' view. And let's maybe start from the end. Anna Bukvych, and then we'll pass on to Ganna Yudkivska, and then Olga in Stockholm, and Tim, and of course Marharyta. Thank you.
Yeah, I think that with this landmark decision, we will receive another investor, like Ukrainian investors, Ukraine, and all investors of all the world receive rounds to protect their investments in the arbitration courts. And I think it will be there are a lot of examples we have already which are proving the effective control, and I think that we will have more cases in the future, and we also need to facilitate and put all our efforts to help to move this case forward.
Well,
Ganna,
thank you
over
very
to
much.
you.
Thank you very much. Briefly, I didn't have time to address one very important question about compensation at expense of Russian property abroad. This is the issue which is widely discussed. And the answer, in my view, is so obvious, and many scholars and practitioners raised it already, but without practical implementation. Now, we all know that property abroad is protected by immunity. There are two steps of immunity. Immunity from jurisdiction of foreign state, which is a key issue in international law, key rule of international law. And then diplomatic immunity, which is a very separate topic. I will not go into that. Diplomatic immunity is very, very difficult to overcome. Now, when it comes to immunity from jurisdiction, again, basic rule of international law, by ratifying the European Convention in 1994, if I remember correctly, Russia ceded jurisdiction in favor of the European Court of Human Rights. So Russia undertook to abide by final judgments of the court, which means, again, it ceded jurisdiction, and now we can easily use it. When Russia refused to enforce any judgment issued against it, we can use this position, this very fact of ceding jurisdiction in favor of the European Court, to overcome this jurisdictional immunity. This was already tried several times, so far unsuccessfully, but on purely procedural ground. No court so far went into merits. Just yesterday, I read a judgment of American court exactly in this respect. But I invite all scholars and practitioners, let's do it. And this is the point where quantity will turn into quality. So I'm happy to cooperate with anyone who will undertake this path. Thank you.
Thank you. Over to you, Olga.
Through the court, Russia has enjoyed the effective control over the eastern Ukraine for 11 years, keeping saying that they are not there. Russia has held effective control over other territories of Ukraine, and this was legally stated by the court. And this decision finally said this to the entire world, I would say. And now this decision of European Courts of Human Rights can be used for as an inspiration, as a manual, as an argument and set of findings by other claimants and by other courts. And all these facts are not relevant just for this decision. They are relevant for the entire conflict in Ukraine. And I think that other states can also enjoy some information from this decision when talking about criteria of effective control. Thank you.
Team, one notable feature of the judgment, in your opinion?
Well, I agree with everything that's been said already. I think perhaps at a global level, at a time when the international rules-based order is under greater pressure and greater threat than it has ever been, this represents the most profound upholding of that international rules-based order. When we were at the hearing, Marharyta and I, in June of 24, one of the messages we wanted to get across to the court was that the world might be living through the equivalent of 1938. And this was the court's opportunity to do what it could to stop us getting to 1939. And fortunately, that was an invitation it took up. And I hope it will prove to be a profound turning point, not just for Ukraine, but for the wider international order.
Thank you, Tim. And Marharyta, for you to conclude.
Thank you. Just I will be very brief in this regard. I'm looking for this judgment for the practical point of view, how we will be able, how it will affect, and I agree that this judgment is implications definitely influence on future ECtHR and other international court decision, but also stress and claims of Ukrainian victims in various jurisdictions, both in Ukraine and in other states where the relevant investigation, but also looking at this judgment, I also realized from the practical point of view that this judgment posed a new challenge for the Council of Europe, first of all for the Committee of Ministers of the Council of Europe, regarding the need to revise or develop the implementation mechanisms of the interstate cases, because it's also now this judgment is under their supervision, and in 2 months we will have the first examination of the Council of Europe of implementation of this judgment. Thank you.
Thank you, Marharyta. As we open the Q&A, I propose that we can take some questions in groups because we are running out of time. So if there are any questions online or from other from our audience in Stockholm and in Kyiv, you can all raise the hand. I'll note the questions down, and then we'll address them all at once. We have a question here in London.
Yeah, I mean, there's been damage in areas that it's pretty clear that Russia doesn't really control, like a massive missile attack in Lviv. Is that completely out of that? Or are there any strategies for going after such damage? I appreciate that may be well over the 300 million, but it's just a thought.
So just to clarify, the question is about the bombardments that are happening not in the east or the south, but the western
places that are clearly outside any line of contact. There's been a fair amount.
And how those claims.
Well, is there anything? Maybe the answer is no. Sorry.
Whether they would fall under the jurisdiction of the European Court of Human Rights.
In any other way, yeah.
Okay.
Yeah.
Any questions in Stockholm or Kyiv?
Yes, we have a question here.
Can I ask from here? Can we discuss a little bit time-bounded effect of this judgment? Because as far as I understand, court covered only events committed by Russia before 16th of September 2022, when Russia withdrew its participation from European Convention of Human Rights. How crucial it can be for victims who lost their properties after this day?
Thank you very much. Any other questions?
We have another question here in Stockholm.
Yes,
Please
and
go ahead.
I have a question to Stockholm, Olga. Thank you for your, we will write them down. Right. And answer it once. Yes, I have a question about this presentation, about the effect of this judgment for investment law. And I was wondering if there has been already any cases that where this European Court of Human Rights judgment was mentioned in investment cases as an argument, at least if you're aware of these cases. Thank you.
Thank you so much. I propose that perhaps, subject to your comments, of course, Marharyta could address the first question, which was about the jurisdiction of the European Court of Human Rights over the claims relating to damage caused to the property in the areas that are under Ukraine's government control, such as Western Ukraine, for example. And then perhaps Tim could address the question about the events after Russia ceded to be a member of the Council of Europe, September 2022, and what happens to the damages caused after that date. And finally, I probably let Olga address the last question about the judgment, whether it was cited or referred to in any investor-state arbitrations today.
Okay.
Thank you. I think I'll start with this first question. Yes, it's quite interesting question whether the bombardment far away from the eastern regions of Ukraine, whether the judgment cover those cases. There is two points we need to take into account in this regard. First one, the court in this judgment indicated that and found violations under Article 2 and 3 and first protocol of the first protocol to the convention, and because of these military attacks and bombardment shellings, and indicated that while delivering this finding, the court indicated that the government confirmed, collaborated that those attacks carried out by the Russian Federation, they are predetermined, pre-planned, and they are intentional, and there is no way, no chance that the Russian officials, while planning these attacks, they do not realize that the type of the weapon they use, the type of missile, they will not harm to civilians and civilian objects. So this is important, and this is quite a huge also victory because for this judgment, because this overruled these findings in the Bukvych and the Father Georgia versus Russia 2 cases. But after this, we need to take into account these that the Russian Federation was party to the convention till 16 September 2022, and I think this part of this question, the response is related to that question for Tim. But the court indicated specifically that its judgment, its jurisdiction covers only the human rights violations before this 16 September 2022, and unfortunately, we already have the cases when our victims submitted individual claims to the court after 16 September 2022 regarding the events and human rights violations after this date. and the court had to dismiss those individual applications, as explaining that this judgment does not, this dismissal does not does not demonstrate that there is no violation, but it's still just because the court does not have this temporal jurisdiction over those cases. So if the case is after 26 September 2022, not before this date, it can be quite challenging to ask the court to overrule this position. But still, our people have the possibility to turn to in such cases with the court judgment or without it to this register for claim for damages. Because this specifically cover all the situation after the full-scale invasion. Thank you.
Thank you, Marharyta. And team, what are the avenues then to pursue the claims that arise in relation to damages caused after September 2022?
Yeah, and if I could just add on that first question, this is the whole point we've been making. This is the central finding of the court, that the fact that damages occurred in Western Ukraine, areas never occupied by Russia, does not mean that Russia is not liable. That's the key breakthrough of the case. It's the single most important decision. So it's absolutely
that's great.
Front and center.
And then we still have 16 September.
Then you go to the temporal point.
War afterwards.
Yeah. So on the temporal point, at one level it's academic because it's pretty clear we can prove up to $300 billion worth of damage occurring prior to the 16th of September. And so anything more than that would have to be part of a peace treaty, part of a voluntary process involving Russia anyway. Insofar as it's not consensual, it seems to me there are at least two routes to recovery of losses occurring after the 16th of September. One, in terms of corporate entities who've suffered damage as a result of acts or omissions occurring prior to the 16th of September. The quantification of those losses runs on after that date, but it's still recoverable. So if, for example, a business is destroyed in August 2022, then there's a violation of that, which has occurred, and an obligation to give just satisfaction. And if that corporate entity can prove future losses running forward many years, there's no reason why in principle it shouldn't recover. Secondly, in terms of individuals, the court's been absolutely clear that in cases concerning detention, and I'm obviously thinking here of the thousands of children in particular deported, but other POWs too, that is a continuing violation which the court has recognized requires a response from Russia still. So I think those are the main points. I mean, it illustrates also this issue of temporal jurisdiction, how sometimes political players can move in a slightly ill-advised fashion. When it was announced that the Parliamentary Assembly of the Council of Europe wanted to expel Russia in early March 2022, the resolution the Assembly came up with was it's recommended Russia is expelled, paragraph 1. Paragraph 2, the legal consequences of this will be considered in due course. It would have been much better if Russia had simply been suspended.
Other way around.
And it would have been much better if people had thought through legal consequences.
Do your homework and then do stuff
Yeah,
after.
but in any event, as I say, in the end, this is an academic debate because the damage caused across the whole territory of Ukraine between February 2022 or going back to 2014, but up to 16th of September 2022 is way north of 300 billion. So in the end, it doesn't matter. And the most important fact is the point that Marharyta's also answered, that jurisdiction extends right across Ukraine.
Thank you, Tim. And on to other avenues, and talking specifically about investment arbitration avenues related to corporates and companies. Olga, on the third question in relation to the use of the ECtHR judgment in investor state arbitration.
Yes, thank you. So it is unusual for investment arbitrations to refer to European Court of Human Rights decision as decision as such, but it is not unusual to use the approaches. And if you ask me about Eastern Ukrainian cases, then the answer is not yet, or at least I don't know about them. But if you ask me about Crimean arbitration cases, then the answer is yes. The tribunal has used the approach from two European Court of Human Rights decision in relation to the effective, in relation to the de facto control at that point in general, or in relation to the particular action. And if you ask me if they referred in text to these decisions, the answer is I don't know, because the tribunal's decisions are not available in public. However, the approaches was used, and you can see that from the enforcement decisions which were published in Switzerland and other countries. Thank you.
I'm sure the reference will be there in due course, and the issue of effective control and elaboration of the European Court of Human Rights will be referenced by investor state tribunals in cases relating to the atrocities in Ukraine and destruction of property and other investor state treaties violations. But we are 9 minutes late. Apologies for that. On that note, I wanted to thank to our audience in Kyiv who gathered at ECtHR. Thank you very much to ECtHR offices in Kyiv for hosting, and to our office in Stockholm for allocating and for having in-person audience there, so that we could meet and discuss these fascinating issues of international and European human rights law, and also, of course, to our audience here in London at White & Case. To the panelists, Marharyta Sokorenko, Timothy, Olga Kuchmiienko, Ganna Yudkivska, and Anna Bukvych, thank you so much for finding the time to join us. And to my wonderful co-moderator, Filipa, excellent in Stockholm, thank you very much for doing this with me and for managing this panel. Thank you all.
Thank you, Natalia. Hi.
Great.